Good morning, everyone. This is Rita Peters, Senior Vice President for Legislative and Grassroots Affairs with Convention of States Action. And I am coming to you solo, it looks like today, for this special broadcast of COS Live. In a few moments, we're expecting a public hearing in the South Dakota Senate State Affairs Committee. You'll hear our legislation referred to here as SJR 503, sponsored by Senator Melhoff. Now let's review a little bit of background information on what you're about to watch. 20 states, as of yesterday, have already passed our Article 5 resolution calling for a convention to propose amendments to the U.S. Constitution on 3 topics: imposing fiscal restraints on the federal government, limiting the power and jurisdiction of the federal government, and setting term limits for members of Congress and federal officials. We are using the Constitution to save it, to propose amendments that will force the feds to abide by responsible fiscal policy, restore constitutional limits, and send the swamp monsters packing. So how did we get here? Well, it all starts with we the people. The Convention of States South Dakota volunteer team has been busy building support across the state and in the legislature for years now. Over 16,000 South Dakotans have signed the COS petition asking their state legislators to vote yes for Convention of States. And that's a lot for a state with a sparse population like South Dakota. Scientific polling shows that a whopping 72% of South Dakotans support the COS resolution to rein in the federal government. We do expect to get a vote this morning in this committee. It's a 9-member committee. And again, we do expect them to vote. So a positive vote this morning would send our COS application then to the floor of the South Dakota Senate. Let me just now give you a brief national update. We had a debate and vote in Kansas this week, debate on Wednesday, and the final floor vote in the Kansas House of Representatives just yesterday. And by a vote of 80-42, Kansas becomes state number 20 to pass our COS application just yesterday. South Dakota is the first state to hold a public hearing this year on Convention of States Action's Article 5 application. So Kansas has a 2-year session. We had already passed in the Senate in 2025, and we're just pending for a floor vote, which again happened yesterday. South Dakota doesn't have 2-year sessions. Their sessions only last 1 year. So that's why today we're starting fresh in the South Dakota Senate at the committee level. And then, as I said, if we pass committee, we'll go on to the floor of the South Dakota Senate. If we pass there, then we do the same process on the House side. So far, a total of 12 states this year have introduced our Article 5 application or had it carry over from last year. Those are Delaware, Hawaii, Illinois, Iowa, Kansas, of course, Massachusetts, New Jersey, North Carolina, Ohio, Pennsylvania, Rhode Island, and South Dakota. 20 states have already passed this resolution. Again, we're on a road to 34 states in order to trigger the nation's first ever Article 5 convention to propose amendments. The 20 states that have already passed the application are Georgia, Alaska, Alabama, Florida, Indiana, Oklahoma, Louisiana, Tennessee, North Dakota, Arizona, Missouri, Texas, Arkansas, Mississippi, Utah, Nebraska, Wisconsin, West Virginia, South Carolina, and now Kansas. Under Article 5 of the Constitution, we need 2/3 of the states to agree on the topic in order for the convention to be called. So now we need 14 more sister states to activate the first ever Article 5 convention. It is very excited. And if you watched our program yesterday, before and after the Kansas vote that gave us our state number 20, you heard us talking about the fact that passing in another state like we did yesterday is going to give us a lot of momentum as we move into these other states like South Dakota. It is impactful to these legislators to see that more and more states are adding their names to the roll to call this Article 5 convention, which again is a limited convention. It lets the states use their power, use their check on the federal government to impose the kind of permanent reforms that our country so desperately needs. Most of us, even across party lines, most Americans agree that it's time for the states to do something about the federal government, which is a runaway federal government, has amassed way too much power and needs to be checked. The states at this point are the only ones who can do it. If you've read Article 5, you know that Article 5 is the part of the Constitution that provides for two different ways for amendments to be proposed to our Constitution. Congress can propose amendments. That's the way we've gotten the 27 amendments we already have. Or the states can propose amendments at a meeting or convention whenever 2/3 of the states agree that amendments on a certain topic are needed. In American history, over 400 applications for a convention to propose amendments have been filed or passed. The reason we've never had a convention yet is because 34 states have never agreed on the agenda for the convention or the topic for the amendments. So that's what we're working at. We're now at 20. We need 14 more. And this is really important. Regardless of whether amendments are proposed by Congress or by the states at a convention, it always takes 38 states, that's 3/4 of the states, to ratify any proposed amendment. So when people tell you this is dangerous, somebody might repeal the Second Amendment, well, nonsense. First of all, there are a number of protections on the process. Secondly, the convention is limited to proposing amendments on the topics stated in the applications that bring the convention about. And finally, 38 states have to ratify any amendment that's proposed at a convention. That is a very high bar. It's very difficult to do. So we don't need to be worried about something crazy happening. That is just nonsense. So don't go for it. The second thing I want to address
I'm
is
going to ask everyone to please take
we're
a
going
seat.
to the hearing
Have
now,
your phones
so
turned,
we're going to
to
take you
silent.
to that coverage.
If you plan on testifying today, please make sure to sign in at the back of the room. If you're testifying and have handouts, please have the pages, distribute them to the committee members. Lobbyists, make sure you're wearing your badge and that your badge is clearly visible. Welcome to those who are joining us online. If you need to contact us, our committee contact information can be found on the legislative website. And this would be the Senate at Senate State Affairs at sdlegislature.gov. Lastly, a reminder that all testimony and all questions are to be addressed through the chair. And for today, I'm going to give you a piece of information before roll call. Our chairman is Jim Melhoff, and he is one of the proponents for one of the bills coming up. So I'm running the meeting today. At this point, I would ask the secretary to please call the roll.
Senator Dybert.
Here.
Jensen.
Here.
Carr.
Here.
Kolbeck.
Here.
Larson. Here. Pischke.
Present.
Voigt.
Here.
Perry.
Here.
Melhoff, excused. Mr. Chairman, we have a quorum.
Okay, thank you. As you announced that, that's great. At this time, the chair will entertain a motion to approve the minutes of the last meeting.
So moved.
Second.
Motion by Senator Pischke, second by Senator Dybert. It's been moved and seconded. And those in favor of approving the minutes, say aye.
Aye.
Those opposed, no. The minutes are approved. At this point, I would ask the pages to come up to the microphones to introduce themselves, stating where they're from, and briefly mentioning their future plans. And the final thing is, tell us what you've learned so far that you'd like to share with us, okay?
Hi, my name is Brianna Sargent. I live here in Pierre. I'm a senior at Stanley County. My future plans are to attend SDSU or NWU to be a social worker or a nurse. And, something I've learned. Yesterday in the Senate when we had a tie, that was something that was quite interesting. And Senator Roll, he informed me on a lot about that. So that was really interesting to hear and listen in on.
My name is Gage Miyake. I'm from Webster, South Dakota. I plan on attending USD in the fall for medical biology and taking the pre-med route. And I guess something I've learned is kind of a new term for me was decorum. So yeah, that was interesting.
Well, we thank you for sharing, and the pages are an integral part of what we do here, and we sometimes forget to tell you how much you're appreciated, but you are greatly appreciated, you're greatly needed, and you guys are doing a fine job. The next thing that we're going to do is I'm going to make an announcement about the meeting. I'm going to, concerning the agenda, just a little bit of a change. We're going to go with SJR 503 first. Then we're going to go with SJR 502 second, and with SJR 501 third. And I think we're going to do a limit of time to 15 minutes for proponents and opponents. And if for some reason we need to go a little over that, the chair will have some lax. We'll let you get by with a little bit. So we'll start off with SJR 503. Are there any proponents?
Mr. Chair, members of the committee, good morning. Jim Melhoff, State Senator, District 24. I'm here as a prime sponsor on SJR 503. It's a resolution calling for an Article 5 Convention of the States to address 3 issues. Number 1 is the size and scope of the federal government. Well, I'm not sure if I'm getting these in order, but these are the 3: size and scope of the federal government, term limits, and fiscal discipline. I did a little research. I provided this last year, but I looked back at the longest serving members of Congress. 65 members in Congress have served over 40 years or more. Of those, 17 of them have died in office, and 10 of them are still serving as we speak. So I think there's definitely a lot of members who have overstayed their usefulness to the country, and I have concerns that maybe they're there for other reasons. We see a lot of news stories about the investing prowess of Nancy Pelosi and others who do quite well by staying in office for that long. The national debt I looked up this morning is $36.48 trillion, and it grows and grows and grows. And though there are some efforts to kind of put the brakes on that, it seems that it's a futile task. I look back on the history of the national debt. I don't know, many of you probably remember in 1994, there was a change in Congress. The Republicans took the House for the first time in in over 40 years, and they did it running on a contract with America. And one of those things in the contract was to pass a balanced budget amendment, which they got through the House. They nearly got it through the Senate. It had 64 yeas, 35 nays. And just one interesting fact, there was a senator from North Dakota who had initially run. His name was Kent Conrad. He ran for his first term, pledging that he would get the federal budget balanced, and if he didn't succeed, that he would not run for re-election, which he stood by his pledge. He did not run. But there was another senator who was well into his 90s and was one of those who died in office. Well, the people in North Dakota thought that Kent Conrad was so great for honoring his pledge, they appointed him to come back, which he did, and then he was reelected, and then he was there to join in with the nays voting against it. He voted against the balanced budget amendment. So he was affected. He totally changed his focus after he returned. And I would stand down at this time, and I'm going to turn it over to our next testifier, who I would say he was one of the yays for the balanced budget amendment back in 1996.
Thank you, Mr. Leader. My name is Rick Santorum. I'm a former senator from Pennsylvania. I testified here last year, and it's great to be back, and thank you for having me. The old line is, I'm here from the government, I'm here to help. Well, I'm here from Washington, D.C., and I need your help. As someone who served there for 16 years, 12 in the Senate and 4 in the House, and ran for president a couple of times, I can tell you that the system is indeed broken. People on the left and right complain about whether, depending on who's in charge, that they're authoritarians or they're exceeding their power and they're doing all these things. And that's because the only people that can check them is the court, and they can't check everything because they simply can't get to everything. And particularly the Supreme Court doesn't have a docket that allows it. There is a need for supervision. There is a need for intervention. I don't know, depending on, again, the left and right sort of agree with that. I mean, you hear all the left now complaining about Donald Trump doing this and doing this and doing this, and then Joe Biden doing this and doing this in the Congress. So there's a general understanding, even though they don't agree on necessarily what, on the problems, they do see that there is an institutional problem in Washington, and it was created a long time ago. It was created because of constitutional changes that were made a little over 100 years ago that changed the dynamic in Washington, D.C. I go back before the 16th and 17th Amendment to the Constitution and look at the size and scope of Washington, and it was irrelevant. What happened in people's lives were governed by their localities and their states, period. The federal government had almost no impact on people's lives until the 16th Amendment with the income tax, which gave the government more power to collect money, and the 17th Amendment, which took your power away to appoint United States senators who, for the first 150 years of the Republic, protected the states and the power the states had and didn't let the federal government run away and do whatever it wanted to do. That changed. So when people say, don't touch the Constitution, the founders had it right. They did, but the Constitution has been changed, and you need to remedy that. That's why I'm here to ask for your help. There are complaints about what this process will do. Here is the reality. People say, we don't know how it'll run. We don't know how people will be appointed. First off, you appoint them. You have resolutions. I think about 15 states so far have already passed delegate selection bills. The states appoint their delegates. How is it run? Well, how do you run? You run because every year you pass a set of rules, right? So you can say, well, we don't know how the South Dakota legislators run. There's no statute that says how it runs. There isn't. But you have rules. Well, where do these rules come from? They could be any rule. You could pass anything. No, you look at what passed before. And then you might make a change or two to those rules every year. But you run by what's not just rules, not by legislation, but also something called precedent. That's how you decide things. That's how courts operate, by precedent. Same thing here. No, we've never had a convention of states under Article 5, but we've had almost 20 conventions of states since the founding. not Article 5 conventions, but other conventions. And guess what? They all ran according to the same rules. And how will this convention run? Look at how those conventions run. And that's what they're going to start from. They may make some tweaks, but the reality is we know how they operate. There's been over 40 conventions prior to the founding of the country. So states and state conventions are something people are very familiar with. It's just a lot of folks who are opposing this aren't familiar with the precedent that's been established there. The other criticism I hear all the time is it's a runaway convention. I can think of a lot of reasons to oppose this, but I can tell you I can't. That's one that doesn't really wash with me, and here's why. The hardest thing to do in America in government is to amend the United States Constitution. There's nothing harder. No state legislature, no city council, no federal issue. Because it takes 3/4 of the votes to pass a constitutional amendment, to ratify a constitutional amendment. That's why we've only had 17 amendments in 250 years. It's hard. Even things that are wildly popular, it's hard to get a constitutional amendment. Why? Because it takes overwhelming consensus. So when people say it could run away and a constitutional convention, a Article 5 convention can propose all these things, first off, I'll deal with that in a second. But assuming that's true, it still has to go back to the states, and both houses of the legislature and the unicam in Nebraska have to both pass it in order for it to be affirmed. What's the easiest thing for a state legislative body to do? Nothing. How do you block a constitutional amendment from being ratified? Do nothing. States don't have to vote no, they just don't vote. It's really hard to get affirmative votes on something like this. And so that's why what comes out of the convention will be things that will naturally be very popular. Otherwise, you're wasting your time. And so the convention will look at things, and I know you have an amendment that's a constitutional amendment, the convention being proposed here also today on limiting the Supreme Court to 9 justices. I think that's a great idea. I think that's something that actually could get ratified if it was sent to the states. But it's things like that they're going to be sent, not radical ideas from the left or the right, but things that the American public would say, okay, that makes sense. This is something we can get behind. This would be good government. This would be good for America, like limiting the president to 2 terms, one of the amendments, establishing the 25th Amendment, a procedure to remove a president. Those are the kinds of things that the country can get behind and get along with, even at a divided time. And so I just share with you that the worry and the concern that somehow or another this is a process we don't understand, this is a process that could run away. Is there a risk? Well, there's risk when you cross a street. There's risk when you get out of bed in the morning. You can't say there's no risk, but I used Justice Scalia's quote. And Justice Scalia said, yes, there's risk, but there's risk tomorrow that the Congress could abolish Christmas. They could do it. They have the power to do it. Will they do it? No, of course they won't do it. Why? Because it's not what the public would be outraged. The same thing here. Is there risk? Yes. But given, again, the high bar, the overwhelming supermajority, the consensus that has to be gathered to get something like this done, the risk is minuscule. I would just remind you that the Congress today could propose amendments to the Constitution. No one's fretting and running to the Congress saying, don't do this. And the reason they don't pass it, I was there for 16 years. We tried to get a constitutional amendment to balance the budget. We came within 1 vote to do it in the Senate. It passed the House. Since then, nothing's come close. In fact, in most sessions of this Congress, they don't even propose amendments. Why? Because it's too darn hard to do. It's darn near impossible to get anything passed. So they don't even try. And so I share with you that this is important to do. The final point I'll make. It's important to do because Congress and the president and Washington needs an intervention. They need supervision. The founders created the Constitution to put you in charge of Washington. You gave up your most important tool, which was to appoint United States senators. They left you one other. Please, as someone who has a lot of experience, 40 years of working in Washington, please help. It doesn't happen very often. And I tell you, I'm speaking for lots of members of the Senate and the House who are very supportive of this, including I would argue that the president has spoken out publicly, very favorable in support of this. This is something that the more time you spend in Washington, the more you realize someone needs to be in charge and have a sheriff that can oversee Washington to put them back on the right track. And I trust you to do that. And more importantly, the founders did. Thank you.
Thank you. Further proponent testimony in the Senate here for Senate Bill number Senate Joint Resolution 503.
Mr. Chairman, members of the committee, I'm Jeffrey Church. I live in Vermillion, South Dakota, and I am a retired Army officer. I retired as a colonel in the United States Army. I spent over 30 years supporting and defending the Constitution of the United States, to include both portions of Article 5. Article 5 is in the original document. It was unanimously put in by our founders. It was not a part of the Bill of Rights. It was not a later amendment. It is in the actual base document of the Constitution, which I and you have sworn to support and defend. And this is one method that we have, as Senator Santorum mentioned, to exercise our rights to support and defend the Constitution through this Article 5 Convention of States. And I would just ask you to look beyond the resolution, look towards the bottom. There are checks that are highlighted in this year's resolution. They haven't been there on the past resolutions, but they address almost every single issue that opponents have talked about. And there are methods to control the commissioners and the topics. And Senator Santorum spoke about how amendments get passed and the high bar that is set for passing of amendments. And I would just ask you to vote in favor of this resolution. Thank you.
We have just a little bit of time left, so we'll take one more from here for a proponent, and then we have 3 online. Keep in mind, we don't need to repeat things, just say what we haven't heard. And if it's just me too, those are good words to hear. Thank you.
Thank you, Mr. Chair and members of the committee. I have 3 papers to send out. 2 are testimonies from people who could not be here. The other one is a handout for you guys. And my name is Shirlee Meier. I am the Volunteer State Director for Convention of States here in South Dakota. My testimony is Rick Santorum has covered a lot of it. There are some things he did not touch on that I want to touch on, and I'll try to make it quickly. Any amendment that is come and made at the convention, once it comes out, it has to be approved by 26 states to even come out of the convention. The wording in that, once it comes out, cannot be changed. If it is changed at any time, that amendment is null and void. So you have over half of the states have to approve the wording and everything of that statement. And it has to go for ratification. At ratification, they cannot change the wording or anything, but it has to be ratified, each amendment, by 38 states in order to become part of the Constitution. And there's another thing I want to address is people call it a constitutional convention. It is not. If you read Article 5 of the Constitution, it says your state legislatures can call a convention for proposing amendments to this Constitution. So you're just opposing amendments. You're not rewriting the Constitution or anything else. You are proposing amendments that has to go through a process. So basically, I'm probably out of time, so I want to thank you, and I'm asking you all to vote yes on SJR 503. Thank you.
Thank you very much. And we'll go further proponent testimony if someone has a Me Too to do in the room. If there's a Me Too, I'll take it. Otherwise, the person that's online is not there. So we're going to move forward. Seeing none, we'll move forward to opponent testimony. And this is on SJR 503.
Morning, Mr. Chairman, members of the committee. I'm Linda Schauer, Concerned Women for America, LAC. May I ask how much time we have?
15 minutes.
Okay. It's interesting that the senator referred to term limits. We passed term limits last year, so I don't know why this is in there. And he talked about the imposition of fiscal restraints and limiting the power of jurisdiction of the federal government. This Constitution already does that. If the lawmakers would just obey it, we wouldn't need such a thing. You got this yellow sheet on your desk, and I hope you had a chance to read it. It has some quotes from the founding fathers and for some attorneys, constitutional attorneys. I'm just going to read some of them, and I hope you have a chance to read them in entirety. From Charles Pinckney, who was a signer of the Constitutional Convention, he said, "Nothing but confusion and contrariety could spring from the experiment of an amendments convention." From James Madison, there are others who urge a second convention with the insidious hope of throwing all things into confusion and of subverting the fabric of just established, if not the Union itself. From Alexander Hamilton, "I dread the more consequence of new attempts because I know that powerful individuals in this and other states are enemies to a general national convention." Furthermore, from some of them, foolhardy. They're describing such an amendments convention. Foolhardy, tragic mistake. I doubt that the Republic could continue. From Herman Pritchett, who wrote an article, Congress and the Article 5 Convention, "It would be convened to draft a single amendment. Could it not undertake to rewrite the entire document, repeal provisions of the Bill of Rights, reverse unpopular Supreme Court decisions, or draft a new constitution?" Justice Scalia wrote, "I certainly would not want a constitutional convention. Woe, who knows what would come of it?" And that was in 2014, he said that. Others, "There's no safeguards to restrain delegates. Put the most basic parts of our democracy at risk. Extremists would have free rein to everything from our systems of checks and balances to our most cherished rights, such as freedom of speech and voting for leaders. Risky, dangerous, no constitutional limits. A dangerous adventure, no safeguards. The entire Constitution will be in play. The First Amendment could disappear, so could gun rights." And also, Glenn Beck was a former strong supporter of the Constitutional Convention. He is not anymore. He cites how the founders have prayed regarding this convention. And he said, "They did not politic, they prayed. I'm not for opening that Constitution anymore because we are not that people anymore. But I withdraw my support. It is because of the fact that this Constitution is wholly inadequate for anyone other than a religious and moral people. We are not those people, and we should not stain this document." Thank you.
Thank you. Further opponent testimony?
My name is, excuse me, my name is Michael Boyle, and I'm a pastor from Parkston, South Dakota. And one of the proponents talked about precedent. And really the only precedent we have is the 1787 convention. Are there other, meetings that states have had? Sure. But once we pass the Constitution, Article 1, Section 10, Clause 3, I think, says that no state can enter into any compact with any other state without approval from Congress. So ever since we passed the Constitution, every single agreement that we've had among the states went through the Electoral College model, and it was passed by Congress under federal authority. So the idea that there's this other way of the states being able to, kind of on their own, be able to pass federal law or influence our Constitution is not a reality. Now, I've been coming up here for the last, I don't know, at least 10 years, probably 12 years, opposing these efforts. And I love this topic, so it doesn't really bother me at all. And you know, there's been many on the other side that have been here for a long time too. But it seems like every single year I come up here, it's you legislators that kind of get tired of this argument, because it's kind of the same argument every year, right? We just come up and make the same pitch. But I'm very excited because this year there is new information that you guys need to know. In November, a district court, a federal court, made a decision about Article 5. And what the decision, so it was actually Convention of States in Kansas. The application was up and they did not get what they needed according to the Kansas Constitution, which was they needed 2/3. So the Kansas Constitution said, hey, if you're going to pass an application for an Article 5 amendment, we want you guys to have 2/3. And they didn't get that, but they did have a majority. And so they went to the court and said, you can't force our application to get 2/3, even though that's what their state legislature had proposed and the people had approved. And so they won in court. And now most likely Kansas will be the next state to approve Convention of States. But in that decision, the federal judge really undermined a lot of the things that you guys have been told by proponents of this bill. And the main argument, if you will, that the defense, which were the people who are trying to uphold the constitutional convention, or the constitutional amendment that Kansas had made, was one, they argued that states can have control as long as they don't take the ultimate decision from the body, and that Section 13 of the Constitution still leaves the power to apply for a convention solely in the hands of the state legislature. But the judge said Article 5 permits no limit on state legislatures' power to ratify amendments or to apply for conventions. The defendants also argued that history and tradition were on their side, and you've heard it this morning. In general, they argue that when history and tradition are appropriately examined, it is clear that the intent of Article 5 was not to limit how states choose to exercise their power. It's you guys that are in control. That was the argument. And the judge struck that down. He said, one, is because Article 5 of the Constitution is the source of the ratification and application power. That power does not derive from state law. Under state law, you do not have the ability to tell the federal government how they are going to run a constitutional convention. And finally, the defendants said that Hawk, which is really the underlying Supreme Court decision that affects this, is an opposite, because application for a convention under Article 5 is a legislative function. And the idea is that you as the legislature get to choose how it's going to go, right? And that's what we've kind of heard on the other side. But the judge struck that down. He said the argument is unconvincing. As noted, the text of Article 5 fails to support treating the ratification clause differently from the application clause. Under Hawk and its progeny, the power extended by Article 5 cannot be restricted by state efforts. So if we look at this application, and one of the proponents decided or suggested that we should look at, kind of towards the bottom. And I totally agree. We should look at that. For example, under Section 9, Article 6, or subsection 6, it says Congress submits any amendments to the Constitution proposed by the convention to the legislatures of the several states for ratification. So this is the idea that we are applying, and we are going to force Congress to send out any proposed amendments to the legislatures. But Article 5 of the Constitution says that Congress gets to decide whether they send it out to the legislatures or whether they send it out to conventions. And so what I'm trying to help you to understand is that there's arguments being made that you're in control of this process. But what this court decided was this process, and it's just the court didn't make it up itself. This is longstanding Supreme Court law. The Article 5 process is a federal process. And even right this minute, as we're considering this argument, right, we are under federal domain. We're under federal law. We cannot, as a state, affect this process by state law. And so if we apply, that's a federal power that the legislature has been given. And when we have the convention itself, it will operate under federal authority. It will not operate under state authority. And when then at the time, if there was an amendment to go out, that would then also operate under federal authority, not under state law. And there is long Supreme Court precedent that this is not, that it is the case that it is federal authority and that state laws will not apply. Even if you put it in the Constitution, like saying, hey, if we're going to apply for this thing, it has to be 2/3 majority. The federal government says, no, you can't encroach on our domain. The Constitution of the United States is superior even to your state constitution. And so you will not, as the state legislature, be in control. Article 5 gives you the opportunity to apply. It doesn't give you to apply with a bunch of, comments or the ability to kind of stranglehold the process. You get to apply. That's the only thing that you get to do. The process will then be determined by Congress. And I would appreciate that you vote no on this. Thank you.
Thank you. Other opponent testimony at this time? Other opponent testimony. We had someone that was online. We don't have anybody online. So when we have somebody that's supposed to be online, if they're not here, I asked if they're here a couple of times. I did it on the proponents, now the opponents. So if there's no one else that's an opponent that's here, we're going to close the remarks and we'll go to a rebuttal, please. And this will be for SJR 503.
Thank you, Mr. Chairman. Just to take some of the comments that were made, first about Justice Scalia, the quote that was quoted with Justice Scalia was a forum in which he and Justice Ginsburg were talking about a constitutional convention to rewrite the Constitution. So there was a discussion, a question asked of them about whether they would be for a rewriting of the federal Constitution. And of course, Justice Scalia, as did Justice Ginsburg, said no, they would not be for rewriting it. What I quoted to you earlier, because I don't want you to think I was quoting something and Justice Scalia's, I quoted Justice Scalia and then you hear something else. What I was quoting was an event that Justice Scalia participated in 1979 when he was a law professor at the University of Chicago, and it was on Article 5. It was the American Enterprise Institute had 4 college professors come and talk about Article 5 of the Constitution and whether we should move forward with a convention to propose amendments to the constitutions by the states. In that, Justice Scalia was the sole person saying that this is what we should do, and that's when he said, is there risk? Yes, there's risk that Congress could outlaw, and this from that debate, outlaw Christmas, but it's a very small risk, and it's a risk I'm willing to take. And I'd be happy to provide you the entire text of that debate where he repeatedly says that he is in favor of it, that he would do it, and that this is something that the country needs because there is a need for an intervention. And I can tell you, having known Justice Scalia very well, his opinion of that did not change, and he was very adamant that there needed to be some intervention. So that's number one. Number two, I want to talk about the Kansas decision. As the gentleman may not know, Kansas passed yesterday. It passed in the House. I think it was 80-42 or something like that. So it passed almost 2-1. But what he was talking about was a situation where Kansas, back in the 1970s, through the initiative process, actually amended their constitution to put a 2/3 requirement in the Constitution of Kansas that any Article 5 resolution had to achieve a 2/3 majority. What the court found was that Article 5 of the Constitution gives the legislature sole authority on calling for a constitution, a convention of states, and that the Kansas Constitution, enacted by the people, usurped that authority, and that and the United States Constitution, through the Supremacy Clause, trumps what the people of Kansas wanted. It also said in that decision, as could have been the case, if the legislature passed a rule in your rules that required a 3/5 or 2/3 or 3/4 majority, they could do so. And they could create a higher bar for themselves. But the public can't limit the legislature because the Constitution gives the authority to the legislature, not the public. So that's what this decision was about. It was passed by, it was ratified. It was again, the decision was handed down by the federal court. And interestingly enough, the Attorney General for the state of Kansas actually agreed with the decision, even though he had to defend the provision, because it is clear the Supremacy Clause gives the Article 5 and the Supremacy Clause gives you, the legislature, sole authority, and it cannot be taken away from you by the people. So that's what that case was about. I don't know what he was discussing, but it was not about the things he was talking about. As far as precedent, I go back and he said that, that the Congress would control, and we don't know what the president is, and the states can't get together. Well, you have to tell the Colorado River Compact that they can't get together, because the Colorado River Compact was a convention of states called by 6 conventions. The federal government had nothing to do with it. Congress did not intervene in one way or another. All 6 states came together. They passed resolutions in each of the states to call the convention. They met, they negotiated a water compact, and it was ratified by the 6 states, and it's operative today. So the idea that states can't do this or the federal government's going to get themselves involved is simply not true, and it happens on a regular basis on a variety of different subjects. With that, I finished, unless there's any questions. Thank you.
Thank you very much. All right, we've heard from the opponents, the proponents, and now I'm going to close the taking of public testimony at this time and open it up to questions by the committee. Questions by the committee. Go ahead.
Thank you. This would be for Mr. Boyle. And while you're coming up, I'll say, I know your passion, you've been here many, many times on this, and you've had many years to think about this. I don't want to put you on the spot, but can you think of one measure that would come out of a convention that would be detrimental to the United States that 38 states would ratify?
Thank you for the question, Chairman. Yes. One of the flyers back there I have is save the Second Amendment and vote no on a constitutional convention. I think, the last convention we had a great compromise, right? You had the big states and the little states, and the compromise was we'll have one body, the Senate, which will be equal in representation, and the Congress or the House will be according to population. And that was a great compromise. The big states, they wanted all the power, and the little states wanted equal power. What's the likely compromise that would come out of the next convention? And I suggest that this would pass most states, is if we just amended the Second Amendment and insert the word responsibly. That the right of the people to responsibly bear arms, should not be infringed. And that would turn a right into a privilege that the government would then be able to claw and destroy our Second Amendment right. And I think that would change the fabric of our country and who we are as a people. Now you say, well, nobody would do that. Well, just look at the 17th Amendment. What did the states do? They gave up their authority, right? So they do that. People get excited about different things, and gun control is obviously something we've been talking about. And what might the people say, hey, I'd be willing to, give that up in order to gain. I think there's a lot of things that people would, especially in our bigger population, say, hey, we can kind of just put responsible on there. And I mean, who really is against responsible gun ownership anyway, right? So I do think that would be one that would be very obvious, and it would, I really believe it would change the fabric of our country very, very bad way.
All right, Michael. Just in case I missed it, could you give your name and all that information? Because the people online always want to know who was that talking.
Yeah. Michael Boyle. I'm from Parkston, South Dakota, Boyle.
Thank you, sir. Other questions, Randy? Excuse me, Senator Dibert.
I have a question to the prime, and I'll let him decide who wants to answer it. It appears that you have 3 separate items in this resolution, and I wanted to confirm that first.
Yes, I believe that's correct.
Follow up, please. So I'm wondering, and I'm trying to learn more about this every day, do the other states have to have the exact same language, or can they do one of these independently and still move it forward?
I'm going to refer to Mr. Santorum.
The answer is that all 20 states have the exact same operative language, and it's critically important that they do. In the history of our country, the legislatures have passed in 49 of the 50 states over 400 calls for a convention, but we've never had a convention. And the reason is because 34 states, or 2/3, and it wasn't always 34, but 34 states haven't passed the exact same language to call a convention. And therefore, the Congress hasn't acted upon it. And so that really begs the question, which is, if it matters to have the exact same language to limit the convention, to call the convention, then it matters at the convention what the language is. And so the idea is, well, we can do whatever we want. They can do whatever they want when they get there. Well, that doesn't make sense. If you can't have a convention unless you all agree on what the exact language is, then that language actually governs the convention. And that's sort of the important point. And that's why, there is an effort right now to say, well, over 34 states have passed some sort of balanced budget amendment. But the reality is 34 states haven't agreed on what the topic of the convention is. For example, Mississippi passed an amendment, passed a resolution that calls for a specific constitutional amendment to balance the budget, and very specifically says, we aren't for any other. So can you aggregate that? And the Congress has said no. And the reason they say no is because the Congress and the Constitution is very clear. We want this to be a limited process that is limited to things that everybody agrees to before they sit down together to debate these issues, which gets to the point the gentleman talked about earlier, which is the provision having to do with the Second Amendment is in the 3 things that we've talked about is to limit this. One is to limit the subject jurisdiction of the federal government, limit the jurisdiction of the federal government. His amendment, rightly or justly or responsibly, whatever he wants to call it, would in fact expand the power of the federal government, because now the federal government has some wiggle room to further regulate this under the Second Amendment. That would be held to be not germane and not applicable to this convention. So remember, the convention is to limit the power, limit the spending, taxation, and limit terms, not to give any room for expansion of any authority.
Last follow-up, please.
That's good.
Okay.
Do we have another question?
Yeah, one more. So how many states have adopted this exact language?
As of yesterday, Kansas became the 20th state to do this exact language. One other state has passed in the House, North Carolina, and is now waiting in the Senate. They come back into session in April.
And you have spoken before, but would you tell everyone who you are one more time? Because the people online would like to hear this.
I'm Rick Santorum. I'm from Pennsylvania, former senator from Pennsylvania. Thank you.
Any other questions from the committee? Seeing no questions, we'll move to committee discussion and/or action. Senator Carr.
I move to pass.
The motion is do pass on Senate Bill SJR 503, and it's moved by Senator Carr and seconded by Senator Pischke. And discussion or comments on that motion, please.
May I, Mr. Chair?
Yes, sir.
Thank you very much. Well, I think I had really good comments last year. I was trying to remember what I said, but my opinion hasn't changed. And I appreciate the discussion. I appreciate those that are willing to come back year after year, whether on either side of this, and continue to have this discussion. I think it's a really healthy discussion to have. And the question for me is answered in a couple things that were brought up. And I really appreciated some of the facts that were laid out regarding what this is. And it's a proposal to amend the Constitution if this all goes through. You know, I've heard this story since I've been here about how this thing will go off the rails and we're going to do God knows what to our country and how we operate. I don't see that. That hasn't been demonstrated to me, despite some of the opposing views. What I do know is every empire that's ever existed has failed at some point. And one of the ways, I think a sure way to ensure that would be to make sure that you economically are not viable and competitive. I look at our debt. I look at some of the things that we're doing to continue to prop up our federal government and our spending. This is not sustainable. It's just not. How long do we want to be, the great United States of America? How long do we want it? Do we want that to last for a couple more decades, or maybe a few more generations, or a few hundred more years? And to me, the alarms are going off. This disaster that folks think could happen with the convention is happening now. And for some reason, we still sit in this boiling pot and we don't want to do anything about it. I shouldn't say we as in everybody, but it's time. It's time that we do something. And I would support this and hope that some of the others that have opposed it in the past would come along so that we can make the changes that are needed in our country. Thank you.
Is there any other discussion on the motion?
Mr. Chair.
Go ahead.
Thank you, Mr. Chair. Just want to state a few things too. I mean, I guess when I come up here to peer, I try to hear both sides of an argument, but I've always resisted legislating from a standpoint of fear, right? The opponents come up here every year and it seems like they always are just throwing out this fear mongering in a way. And I don't like that argument. You always talk about what could happen, what might happen. I might have been in a car accident on the way to the Capitol today. And if that happens, I'll be called home to the good Lord. But that'd be great. But here we are with this proposal, and we need to do something, right? How long are we going to continue down this road? Like the good senator made some excellent comments, almost better than last year. And with this unsustainable debt. And the opponents, I've talked to them offline, and they talked about, well, we need to just fix this within Congress. Okay, that's great. Let's send some people to Congress that actually have some mental fortitude to do the right thing. When's that going to happen? I don't know. It doesn't seem to ever happen. It seems like they get out there and they're all feathers of the same bird. No matter if you're left or right, you're always voting for more debt. So that's why I think that this is what we need to do. This is a tool in our toolbox, and I would urge the committee to send this to the floor unanimously.
Other comments?
Sure.
Mr.
Thank you, Mr. Chair. Yeah, I think we've had a very good discussion here today. I think the situation that we face in our nation at this time, I mean, we are definitely a kettle of frogs on the burner, and we need to do something because it's getting pretty hot, and it will continue to get hotter. We have dealt with a number of other Article 5 bills. In fact, there's another one here today, but I would note that this one covers 3 issues that I think there's broad consensus on that need to be addressed at the federal level, which is the size and scope, power fiscal responsibility, term limits. And this particular resolution has already received 20 votes for ratification. So it's kind of a race to 34. I would urge, I mean, if you support those things, I would urge your support for that, and let's move the bar. Let's get to 34. We can be 21, possibly. We're in competition to be the 21st state, and hopefully we'll get there this year. So I'd urge your full support of this.
Thank you. Any other comments? Senator Kevin Johnson.
Thank you, Mr. Chair. The Second Amendment's the one that's always gets thrown out there first on this argument. We have more states now with constitutional carry. The courts have been moving further to the right to support our constitutional right to carry, our constitutional right to own and possess and firearms. We have the ATF reducing regulations all the time. I find it almost impossible to believe. We have enough states right now that have constitutional carry that would never ratify this. You know, I think the Second Amendment is probably the strongest argument, but in my lifetime, it'll never happen that 38 states will agree. So thank you for your time, Mr. Chair.
A small comment from Senator Dybert.
Very short. Thank you. Well, about 6 years ago, I was first approached with this, and I've been very cautious to understand it. And those of you that know me know that I want the details. And I am at the point now that I'm ready to move this forward. So I thank you for your patience.
Thank you, Senator Dybert. Any other comments? Senator Voigt.
Thank you, Mr. Chair. Perspective in terms of what is occurring. It appears that we're all in the same pot, and the water is not tepid anymore. It's come to a boil. It can only boil so long and there's no water left. That's a concern that I have. I don't want this country to get fried because we didn't have the courage to make a change when it needed to be changed.
Thank you, Senator. Any other comments? I'm going to give you a comment, and that is that we've had good information from the proponents and from the opponents. And this bill is now, I'm going to shortly call the roll. But before I do that, I just want to make sure that everybody knows what the bill is. SJR 503, applying to the United States Congress for the Convention of States to propose amendments to the United States Constitution regarding the imposition of physical restraints on federal government, further limiting the power and the jurisdiction of the federal government, and limiting the terms of office for members of Congress and other federal officials. This was a motion by Carr, a second by Pischke. We will now call the question, Mr. Secretary.
Senator Dybert.
Aye.
Jensen.
Aye.
Carr.
Aye.
Colbeck.
Aye.
Larson.
No.
Pischke.
Aye.
Voigt.
Aye.
Perry.
Aye.
Melhoff.
Aye.
Mr. Chairman, we have 8 ayes, 1 nay.
This has received an affirmative vote by the membership of this committee. It is passed. And we'll send it to the floor with a due pass. Any questions? At this time, I'm going to turn the gavel back over to, no, I'm not going to do that.
It's up to you. I'll take it if you.
No, you're.
All right, folks, it is another great day for Convention of States. You have just been watching a hearing of the South Dakota Senate State Affairs Committee in consideration of our Article 5 Convention of States legislation, SJR 503. As you just heard, the vote was 8-1. That's an improvement over last year's 7-2. I think it was a party line vote. I think there's one Democrat on that committee. So, wow, we have just passed the South Dakota Senate State Affairs Committee with a great vote of 8-1. I'll give you a brief recap in case you didn't catch the whole thing. Senator Jim Melhoff, who, by the way, is the chair of this committee, introduced our resolution. He's our primary Senate sponsor. He did a great job explaining it and setting it up. Then we heard from our senior advisor, Senator Rick Santorum, who did an incredible job of explaining why this country so desperately needs the states to use their Article 5 power to propose amendments to put the federal government back in its constitutional box. We heard from two volunteers, including South Dakota Volunteer State Director Shirlee Meier, who has been working for years on this and doing a great job. She did a wonderful job of explaining the protections on the Article 5 convention process. Then we got to a couple of opponents. I think we had 2 proponents and 2 opponents. Concerned Women for America, their primary argument was that the Constitution already limits federal power and jurisdiction. Well, yes. But is there anybody who would really say we don't need more limits on federal power and jurisdiction, that would be a bad thing? She took some founding fathers quotes out of context. Our opponents really like to do that. And then she talked about, she's afraid that we could see our gun rights disappear. Well, show me your math. And this was pointed out by several others later. Show me the 26 states at the convention who would do that, even though it goes against the 34 applications that we're working to get passed that give the convention its power. Doing anything to the Second Amendment would be outside the scope, clearly. But show me 26 states who would support modifying, weakening, or repealing the Second Amendment. And then show me your 38 states that would ratify that. It's not going to happen. Even one of the senators on the committee made that point at the end. That is not going to happen in his lifetime. It's just fear-mongering. Then we heard from a pastor. Oh my goodness, bless his heart. The poor guy is really confused about a whole lot of things. He started out by saying the only precedent for an Article 5 convention is the 1787 Constitutional Convention. Well, no, there was no Article 5 then. So it is not a precedent at all for an Article 5 convention. He referred at one point to the Constitution's Interstate Compact Clause, which is a totally different animal than an Article 5 convention. He claimed he had new information, and we found out he was referring to the Kansas Federal District Court decision that ruled that Kansas's 2/3 requirement for its legislature to pass an Article 5 convention, the federal district court in Kansas ruled that unconstitutional because it violates Article 5. It sets a higher bar than the Constitution, the federal Constitution, provides. And oh my goodness, I don't even know where to start. Rick did a pretty good job of coming back and explaining what that court decision held, but this gentleman is really confused about that ruling. He said at one point, you guys don't have the power to tell the federal government how they run a convention. Well, the federal government doesn't run the convention. The Convention of States is something that is applied for and led and determined by the state legislatures, not the federal government. Congress has a very limited ministerial role in the process. And Rick gave a great rebuttal. I love that he was given the opportunity to just clarify things and rebut some of the false information that was spread. Then they went to questions from the committee members. And the committee members did a great job. Many of them spoke and explained why they're supporting this application, SJR 503. And Senator Pischke really took people to task for trying to get them to legislate out of fear, as he put it. He labeled the opponents as what they are. They're fear mongers. And I love that he did that. Senator Pischke has been a longtime champion for Convention of States there in South Dakota, and we appreciate him. Then we heard from Senator Dybert, who used to be an opponent of this not that long ago, I think even last year. But he explained that it is time for us to do this. It's time for the states to use their power. And he is now a supporter. He voted in favor. It was great to see that. So this was a great committee hearing. And if you're wondering why there weren't a whole lot of proponents in the room, first of all, they knew that there was going to be a very short allotment of time to give their testimony. Secondly, Pierre is really hard to get to in South Dakota. So volunteers have to come a long way to be there. And I'm sure they're saving more of their firepower for the House side when, Lord willing, we pass on the Senate floor, which could happen as early as next week. Then we'll move to the House, where last year is where we got hung up. So I'm sure our South Dakota volunteers are trying to save their firepower, their travel time to get there when we're on the House side. And I think that's a great strategy. So thank you to our South Dakota team. Thank you to the South Dakota Senate State Affairs Committee, which again has just voted do pass on our Convention of States application by a vote of 8-1. So that's all for us today. I would encourage you to subscribe, share, and catch all the action at conventionofstates.com/COS live. Tune in tonight at 8:00 p.m. Eastern Time for a special documentary film from our staff writer, Jake Fay. It's called The Story of the National Debt. Until next time, this is Rita Peters for COS Live.